Attention all oath keepers in the Queensland Magistrates Court. I'm producing this video prior to attending the next criminal court hearing due to the actions of Magistrate Dwyer in the past hearing, where everyone who had public interest in this case was removed from the court and putting security guards at the doors so that no one can hear what is happening inside the courtroom. There was no jury. These people removed included a Justice of the Peace of New South Wales and Queensland, and I was denied a Mackenzie friend to sit with myself in the hearing to hear what was going on in the courtroom. I would like to explain my case to interested Australians, as I'm only looking for natural justice and the opportunity to prove that crimes did exist in the Federal Magistrates Court, which is the family law proceedings, and this video is to ensure I'm not obstructed and be able to expose the crimes without fear of further crimes transpiring without witnesses. I raised two criminal court cases for the case which has been running in the Federal Magistrates Family Court for 4 years. A few things to consider was a registered lawyer with the High Court of Australia was removed from my case without any charges and given a bill of $9,999, and when trying to appeal a decision, the transcripts were not given as per what was promised by Federal Magistrate DMAC until the 27th day of the 28th day appeal process. While waiting for the transcripts, I and my lawyer sent emails to Auscripts where the courts were suggesting they didn't have the transcripts, and Auscripts had confirmed that the transcripts were sent before 48 hours after the last court date. It was either the courts were lying or it was Auscripts. However, they did not turn up, and I alleged that they were altered transcripts. Due to the action of my lawyer wanting to expose crimes conducted, and including lawyers assisting writing affidavits knowing them to be false and misleading and outright fraudulent made by Legal Aid Queensland, Magistrate DMAC has tried to remove uncontested affidavits from being spoken about within the courtroom. Magistrate DMAC went as far as to ensure all evidence was thrown out, and by doing so, that it was not mentioned when considering the fate of my daughter. The magistrate was ignoring such things as the child had to travel court-ordered 544 kilometres to see a parent, when both the child and parents lived only 8 kilometres away from each other. Affidavits written by lawyers were fabricated and written by lawyers and signed by their clients pretending they had not written them. Court orders were ensuring that a child had to suffer, and or a good parent stopped the contact, or complaining continuously for the torture of both of them to be stopped. The magistrate wanted to conceal everything and brought a good psychiatrist in who's been working for the courts for 20 years to assist when not wanting to deal with law with these crimes. The psychiatrist, on a one-on-one interview, threatened to destroy myself should I bring up criminal activity in the courtroom. That psychiatrist told me that he was employed by the courts to destroy people in court should they not heed to his instruction, and threatened to do so, and saying such things only after confirming my tape recording device was off. I took 2 tape recording devices, knowing what to expect when there was so much criminal activity happening.
As a Justice of the Peace appointed by the Attorney-General, I do have public interest in this case, as do other Justices of the Peace within Australia, and can attest that we did hear the recordings of Dr. Chalk and are very aware of the threats uttered directing Mr. Aster not to speak of crimes, or it was his job to destroy people in court.
The psychiatrist was asked by myself in the family court trial. He denied threatening myself and denied he stated the words, "I destroy people in court," under the penalty of perjury. Everyone knows it is an offence to threaten or intimidate a witness or lie in court. Magistrate DMAC refused to listen to the recordings in open court and pretended not to be able to hear these recordings.
As a Justice of the Peace, I did hear threats clearly and was able to raise an accurate transcript of the assessment conducted by Dr. Chalk. I do not believe any person, including the presiding magistrate, could not hear these threats unless they had a severe hearing impairment.
After the magistrate, pretending not to hear the recordings, did threaten that should I not surrender all the originals and all copies to her, of both the psychiatrist and the judicial officers that she could raise court orders to ensure I never see my daughter again, and threatened to do so. Dr. Chalk was promised by the magistrate to ensure that I surrendered the recordings. He then spoke to the magistrate and stated that I was a danger to society, which again was removed from court transcripts. I raised 2 criminal indictments after there was no government agency, including the Federal Attorney General's Office, and the Chief Federal Magistrate ignored that it is their primary role to ensure everyone, in accordance with the Magna Carta, receives court orders on a timely basis for natural justice to occur. I never received court orders for a period longer than 12 months. Courts will not accept any appeals unless there is a court order attached. I ended up arresting the federal magistrate and proceeding with charging the magistrate, and now having these proceedings in the same court system, I do believe that everything has been arranged to ensure a cover-up, and lawyers protecting lawyers and judges protecting judges from this ever being seen by a jury of my peers. Here are the reasons why I did 2 criminal court cases rather than 1. Having full knowledge that these cases are normally never seen by the public due to, firstly, a psychiatrist used to hide and deal with matters rather than using law to determine them. Secondly, normally the mental anguish of these cases ensure that a person is totally destroyed and without fight to continue, and all funds are exhausted within a 4-year court case, ensures that there is no protection against crimes conducted by a family court. It is very hard to deal with crime, especially when the Federal Attorney General ignores these crimes, and especially where there are over 20,000 cases per year here in Australia where they go through the family courts and lawyers are taking the majority of the family's wealth, and where the Attorney General ignores being a lawyer and protecting lawyers in order to do with gagging legislation in protecting them, so that media do not know what is happening to the families and cannot speak of it to media. Irrespective of alleged crime, or if it's real or not real, I have the right to prove that crime exists, as do all Australians, no matter if there is illness or poverty or not being a lawyer themselves. However, the odds of being successful would be 1 in a trillion who possess the endurance and the legal ability to push through the depression of what has transpired. This is the first court case, either in UK, USA or anywhere, where a layperson has a criminal indictment on a judge. The judges and magistrates are protected by law by the way of getting free legal assistance by the legislated government organisation called the Australian Government Solicitor. These people have Queen's Counsels defending them, the highest calibre of lawyers internationally. State police are not permitted to deal with crimes conducted in Federal Magistrates Court. Federal police will not investigate, and have been informed that they will never investigate a Federal Magistrate, according to Agent Kim Dwyer, second in charge of the Crimes Unit of the Australian Federal Police. The Federal Attorney General has ensured that these people are protected to continue committing crimes against the people of Australia, and allowing courts to conceal this crime and destroying anyone whom attempts to expose these crimes. Here is how the court system works. Family court matters are run in federal courts, so therefore state police are refusing to deal or investigate alleged crime due to being ordered to do so by their superior officers, telling the junior officers not to keep their oaths, which is to deal with all crime, irrespective if it is state or federal crime. Anything that happens in federal court does constitute being charged at federal level, but at state level courts. Any charges when in a federal jurisdiction are charged using Commonwealth statute, as an example the Crimes Act of 1914. State courts are permitted to deal with crimes committed either state or federal. Federal courts are not permitted to deal with crime, however the Federal Magistrates Court in family matters must deal with all crimes presented in their jurisdiction, However, this is ignored by the courts to achieve ensuring protecting of lawyers to assist draw their cases out and including creating false gender wars and reward the party whom is assisting them in extending these cases. I can prove this beyond any doubt to a jury by way of reviewing of my case in a proper court. So we have a federal court, a state court, the Australian Government Solicitor, and the next is that we have the CEO of the Commonwealth Director of Public Prosecutions. Now the DPP has the authority via its CEO to take over any case issued in the name of a private prosecutor, and a DPP has no authority to investigate matters. If the CEO takes the case, can, without having evidence or being able to investigate, can, on the basis that courts are holding the recordings, can state that it is not a prima facie case, meaning there is no evidence supporting the crime. The Australian Government Solicitor knows that without the recordings that I cannot prove the transcripts were fabricated. The Australian Government Solicitor knows that the DPP have no ability legislated and arranged to be such by the Federal Attorney General. So if the CEO's decision is to take the case, can strike the case from the record. I, as a Commonwealth public official, and deemed by legislation to be one, do this case for the Crown. So therefore the case is Regina versus the person charged. So therefore I am no longer acting as a mere single identity. I act for the Crown, and by doing so invoke the rights not to be obstructed by the CEO or anyone and carry out this official function. Irrespective of my role as a Commonwealth public official, even the CEO knows that should he take over this case, and where the courts have denied giving the recordings to state police to verify that they are protecting themselves from being exposed. When the courts refuse to give recordings to state police, then something is very seriously wrong with our courts. As this was an administrative process, I am entitled to these recordings under the Freedom of Information Act, as per Commonwealth legislation. The court's head of staff, Mr. Cotter, refused to surrender these recordings to state police so that they can confirm crime exists, and I would have a prima facie case before the courts. On the other criminal case, we have an independent psychiatrist under criminal indictment. He is not entitled to the Australian Government Solicitor defending him. Therefore, his own case, he appointed a law firm to act on his behalf. This is normal. That lawyer tendered altered transcripts, and Dr. Chalk would have known they were altered from the spoken word in the court to what was written. His lawyer knew that the CEO of the DPP could also take over his case due to the fact that it was Commonwealth charges being laid, and that I had the recording, so therefore was a prima facie case. Therefore, he did not ask the CEO of DPP to take over this case. I won't release the evidence until there is a plea of guilty or not guilty in court record before I give the evidence. This is the same as what police do in all criminal proceedings. These altered transcripts were going to be used as an exhibit to the courts, as it was submitted via affidavit by his lawyer. The lawyer asked by way of verbal application to have me tried as a vexatious litigant, knowing that the recordings were not subpoenaed, and most people do not even know how to subpoena the recordings, especially when it's not the court that actually make the recordings. It is a company called Osquips Pty Limited. These people, without your permission or consent, do these recordings and are not a registered party in the proceedings. The courts and Oscript charge $5 per 100 words, so therefore making a profit on the transcripts. The dividing of this profit is a commercial agreement, which I have also subpoenaed for the asking. The courts are a commercial enterprise, and in accordance with the Australian Constitution cannot be a corporation. The Constitution is above all law and is to be obeyed by this government, and only way to alter the Constitution is by voting of all Australians. The law states we must have a referendum, just like we believe we were voting to remove the Queen for changing the Australian flag.